Hello and welcome to the screencast for College Now, Contemporary Moral Issues, Lehman College, Spring 2020. This week we're going to look at the moral issues surrounding the death penalty. I have this as part 1, but if the video runs a little bit long, I'll break it up into parts A and parts B. We're going to look at the first 3 sections within this section for this Tuesday class, and then we'll look at the final 3 articles for the Thursday session. I have the titles here for you. So there's, as always, the introductory section by the editor of the textbook, Mark Timmons, and that's from pages 359 to 363. Then we'll look at an article from Kant and an article from Stephen Nathanson. So here's the introduction. In 1976, the U.S. lifted a several-year moratorium on using the death penalty. So a moratorium is where there's a temporary ban or a temporary blanket put down on something while people can consider the reasons why you may or may not continue to do any sort of practice. So the Supreme Court had put a moratorium on using the death penalty for several years, lifted it under specific conditions in 1976, and that ushered in the so-called modern era of capital punishment in this country. Timmons talks about how support for the death penalty, at least with conditions, has been consistently high in the United States. He has 64% of people saying that they supported the death penalty in 2003. But there was a caveat. Whenever the other option, the alternative option of life without parole, was put in comparison with the death penalty, the support for the death penalty dropped. So it went from 60% in support to only 50% when life without parole was put onto the table. So that's pretty consistently high, but it's not necessarily unalterable, depending on the other conditions surrounding the support or lack of support for the death penalty. Of course, those are legal issues, and as with many problems that we grapple with, the legal is often intertwined with moral, but they're not exactly the same thing. We might consider what moral reasons we have for or against an issue when we make laws, but the morality of something is separate to which laws happen to be in place at the moment. Remember that when we think about what is moral and what is immoral, we look at reasons why we think we ought to behave in a certain way or ought not to behave in a certain way. So Timmons thinks if we want to decide whether or not we support the death penalty, we need to consider these 2 questions. 1, is the death penalty ever morally permissible as a form of punishment? Is there any ever good reason to execute someone as an arm of the state? And 2, if it is ever morally permitted, what explains it? Why is it okay? If it's not okay to take the life of someone under normal circumstances, why should it be okay for the state to decide that it's okay to execute some criminals? And as always, he has some definitions for us. There is a range of issues you can take, or a range of positions you can take on whether or not the death penalty should be permissible. And instead of a spectrum here, he just gives us the 2 extreme positions, because the nature of support for the death penalty is a little bit more extreme. It's hard to have a moderate position. You can be an abolitionist, where you think the death penalty should be abolished in all cases, or a retentionist, which you think the death penalty should be available as a punishment, at least in some circumstances. So that some circumstances part does give you a little bit of wiggle room to be more of a moderate, on this position. But at the same time, it's either or. You either think it's okay or it's not. And if you think that it's morally acceptable in some situations, it's on you to give us evidence and justification as to why it's okay. And then Timmons takes a step back. Why do we have the right to punish anyone ever? Why should some group of people be sanctioned in inflicting harm on another person? Before we even get into that, though, we have to think about what punishment is in the first place. So he gives us 5 criteria of what counts as a legal punishment. He says it has to involve some sort of unpleasant or painful consequences for the person who's committed the crime. Otherwise, it wouldn't count as a punishment. And number 2, it can only be administered if the person who is going to be punished has committed an offense against the legal rules that are publicly available to everybody. 3, the person punished must be the actual offender, and it must be for their particular offense. 4, it must be administered by some other person. What they mean is someone who wasn't the victim and wasn't the offender themselves. Someone might feel guilty, have remorse, but it doesn't count as a legal punishment unless a neutral party who is a representative of the same legal system, that's number 5, is inflicting the punishment. So now we have a definition of legal punishment, but that still doesn't tell us why we have the right to punish them at all. So what do we think punishment will accomplish? Well, there are 2 schools of thought for this. It could be retribution. So retribution is getting back what you deserve. Or the second school of thought, protection from consequences. So yes, the first one, people should get what they deserve. Second one, people in society should be protected from the consequences of criminal behavior. So now we have 2 more questions that we have to answer if we want to justify our uses of punishment. So both retribution and consequentialism will need to answer these questions. And of course, they're going to end up answering them in different ways. The first one is, what, if anything, morally justifies the practice of punishment? And 2, what kind of punishment should we inflict? If we're given any sort of legal offense, whether it's stealing, murder, drug use, which punishments are appropriate and how do we decide? First, retribution. And these R1 and R2 are 2 premises or conclusions or pieces of evidence, I guess I should say it's an argument, as to why punishment is morally deserved and what type of punishment we should give out. So the first retributive premise says that what morally justifies punishment of wrongdoers is that those who break the law deserve to be punished. So we're all under the same system of publicly available laws, and the person who commits the wrong deserves punishment for their actions. And 2, the particular punishment for a particular offense should, quote unquote, fit the crime. Meaning that if it's a minor crime, it shouldn't be a severe punishment. And if it's a severe crime, it shouldn't be a minor punishment. Now, one of the principles that underlie retributive theory is an eye for an eye. So you steal and you deserve something stolen from you. You kill, you deserve to be killed in return. And this has as evidence underlying it the principle of proportionality. So the morality of punishment, the reason we are allowed to punish another human being, rests in the fact that they caused suffering to other people and they need to get it back in proportion to the suffering that they caused. So it's balanced somehow. And of course, this supports capital punishment, because if you commit murder, you have then forfeited your own life. Whereas the consequentialist theory, remember, only focused on consequences, has these two pieces of evidence to support it. They say punishment is only a morally okay thing to do, justified, if and only if the practice of punishment compared to any other response to crime will likely produce as much overall intrinsic value as would any other practice. So what would another practice be? We could try and rehabilitate people. We could move them to a different part of the country. I don't know. Punishment, though, needs to create good consequences for the consequentialist. And then they say a specific punishment is only justified if it does the same thing. It produces at least as much overall intrinsic value as any other alternative punishment. So we have someone who's convicted of murdering, and we have a range of things that we could do. Life without parole, or a long prison sentence, or capital punishment. So the consequentialist would have to look at the range of punishments available and see which ones produced the best consequences. But you might notice that instead of utility or happiness in these premises to try and prove the consequentialist theory, it has intrinsic value. So what is that, and why is that there instead of utility or happiness? Timmons says preserving human life seems to be the strongest contender for something that has intrinsic value. And that means it has value not dependent on anything else external to it. It is valuable in and of itself. So we wouldn't say that money has intrinsic value. It has extrinsic value because it gets us some other thing that we want. We might want security for ourselves and our loved ones, and that might be the intrinsic value that drives us to go to work and get a bank account and save money. So, of course, happiness or utility has been argued to be an intrinsic value, but another thing that you could substitute there would be safety, security, or the value of human life itself. And one thing that we might do to protect this intrinsic value is deter future crimes, or even deter crimes before they happen. Because if a potential criminal knows that they're going to have a harsh sentence if they commit such a crime and they're caught, it might stop them before they even do it. And of course, once a crime has been committed and we recognize that this person might do it again, we might want to prevent this person from committing future crimes. So these are positive things that we could protect if we instituted any particular punishment. We could think about it in terms of execution, though. Would having the death penalty on the table deter people from committing so-called capital crimes? And would it prevent future capital crimes from occurring? So these are the positive things that someone who's a consequentialist would argue could come from the death penalty. But of course, if they're being intellectually honest, they can also say some harms would occur. So we have to balance those with whatever positives might happen. And Timmons says some of the bad things that could happen, of course, punishing the innocent. Executing the innocent might seem like one of the worst things that a state can do. This one's kind of counterintuitive, and we won't encounter it until Thursday. But some people have argued that having capital punishment as a legal option has incited more murder and more violence than it has deterred. And then, of course, the financial cost. There have been many, many studies that show death penalty cases cost society as a whole a lot more money than long prison sentences or even life prison sentences without parole. So now that we've looked at the overall landscape of the types of views that you can have, we'll move on to a specific argument. And first, on page 364, our textbook has Kant, the originator of deontology or duty theories of morality. Remember again, as in comparison with consequentialists, Kant's theories of duty only care about what's going on inside your head, your intentions, the way that you structure your own behavior, because he thinks that's all we can control. The consequences are too messy and they don't provide objective rules for how we should behave and how we should not behave. First, I want to note that as a first edition textbook, this one has all of the dates wrong. It says in the introduction that he published the Metaphysics of Morals in 1997, which is ridiculous. And then in the bottom it says 1887, when in reality, of course, it was 1797. Kant was alive and active as a philosopher in the mid to late 1700s. And when he publishes this particular piece in 1797, his moral theory had been out and circulating amongst the population for a while. So he was often asked how he thinks it would be justified to apply his principles of morality to specific cases. Remember, he has these universal principles of morality. He stated them in two different ways, but he thought they were different wordings of the same universal principle that applies for everyone in all cases. Now, the first one, remember, is never use anybody as a mere means, but only as an end in themselves. And then the second version is the universalization principle. If you universalize your motives for acting, could it consistently be applied to every single person in society if they were in relevantly similar conditions as you? Okay, so he thinks for any crime, his principles, or his principle said in two different ways, justify just talonus. I don't know if I've pronounced that properly, unfortunately, but remember that's the Latin phrasing for the eye for an eye principle. You deserve exactly what you put out into the world. So how does he justify this? First, again, he gives us definitions. He lets us know exactly what he's talking about. So there is no confusion, vagueness, or ambiguity about what he means. At least that's the intention. And he says that a crime, the definition of a crime, is any transgression of a public law which makes him who commits it incapable of being a citizen. It's a really interesting definition. What does it mean to be a citizen, and why should a crime make you incapable of being such? Of course, I think one way to interpret it is that we're all part of this moral society in which the bedrock rule is to respect each other's humanity. And when you transgress a law, you are disrespecting the humanity of whoever is harmed. He then breaks it up into two different types of crime: private crime and public crime. And this is echoed in contemporary civil and criminal court, but for slightly different reasons. So he says a private crime is a civil court matter, and it is when the criminal's actions don't harm the fabric of society at large. They are individual matters. You harm one or several individuals. But with public crime, this is dealt with in criminal court, and it does affect society at large. So you might have only murdered one or two people, but the idea is that the act of murder is so bad that it threatens the fabric of society or civilization. then there are two different types of punishment. We'll go to the bottom one first. Natural punishment. And here's a little quote. A natural punishment is crime as vice punishes itself and does not come within the cognizance of the legislator. So there's this idea that there's a natural order to things. There's a certain way that our bodies work, there's a certain way that our minds work, and if we act in accordance with those, we will have a more pleasant life. For example, say, if we eat right, we'll be fitter for longer. If we're kind, the people around us will be a lot more pleasant. Whereas if we eat incorrectly, we're punishing ourselves because we're damaging our bodies and our lives are going to be less pleasant. When it comes to sort of mental, psychological things, he thinks that we're brutalizing ourselves. So if we're cruel, if we're violent, we're going to live a life of cruelty and violence, which is itself a punishment. But that's not what we're concerned with when we think about legal punishment or juridical punishment. He says it can never be promoted, or it can never be used for the promotion of the good. And his direct target right there is the consequentialists, are the consequentialists. Because they're saying that when we punish someone, we are punishing them for the greater good. And he says that doesn't work. It's too messy. It can only be in direct response to what the person deserves through their actions. I have the little Y there because I want you to look at one quote on page 365 here, where he says, "Justice would cease to be justice if it were bartered away for any consideration whatsoever." So he has a really narrow view of what justice is. It's very individualistic. And he doesn't think that society as a whole comes into play with a specific example of injustice. Now, he does think that whatever motivations you have can damage society at large. But when you commit an individual crime, there are individual harms that need to be remedied. And they are all based on the principle of equality. If you recall, one of the reasons or justifications or bits of evidence for his two formulations of the moral rule, it's that we're all morally equal. No one person is more human than another person, and that's one of the reasons that we all deserve moral respect. And that means when we commit a crime, this principle is still into play, and that's why eye for an eye is justified. So you commit a crime and you deserve the equal kind of suffering or crime back against you. Because we chose to commit that crime. We had the maxim in our head that it was okay for us to do this thing at this time. So, of course, this supports the death penalty. If we have intentionally killed another human being, we deserve to die in return. And he puts it in another way, that whoever steals anything makes the property of all insecure. He therefore robs himself of all security and property according to the right of retaliation. Okay, so it's another application of the principle of equality. Punishment must match the crime exactly. And he does mention briefly how sometimes it's not so easy to do the crime exactly in reverse. So he says it's the role of the judiciary to figure out a punishment that is exact. And that might seem a little fuzzy to us, and it's certainly going to seem unsupportable to our next author, who is Stephen Nathanson. But it does look like this video is running a little bit long, so we are going to conclude here the death penalty part 1A. And then in the second video, we will only look at Stephen Nathanson's An Eye for an Eye, the death penalty part 1B. As always, please ask questions below the video or on Blackboard's discussion board system if you have any confusions, questions, or comments.